Welcome, everybody. My name is Tom Beto. I'm a board member of the James E. Holshouser Jr. Speaker Series. The other board members include George Little, who's chair of the Sand Hills Community College Board of Trustees, Larry Cadell, who's the vice chair of that board, John Rowerdink, Kay Wilt, who just came in. Where are you, Kay? She is the chair of the North Carolina Federation of Republican Women, so she's on the move all the time. Stephen Lader is our attorney, and Jim Busby keeps the books. We are a 501c3 nonpartisan organization that strives to bring you experts on the issues of the day. Last year was highlighted by a visit with Dr. Ben Carson, who talked about medical innovation and the criticality of education in keeping the American innovative engine humming. While with us, he also participated in a panel discussion with local healthcare executives and a breakfast with local community service and charitable organizations. So we used him very wisely and well on that weekend. Last fall, we had former UN ambassador and presidential candidate Nikki Haley. She talked about strong, decisive women, which are highlighted in her book, If You Want Something Done, Ask a Woman. So far in 2023, we've had a team from the Heritage Foundation to discuss our southern and northern border crises and to demonstrate using cell phone data that we are all on the border, even here in Pinehurst. Gordon Chang was with us in April to shed light on our relationship with China and the hazards of that relationship. Today, we are fortunate to have Eugene Scalia, former Secretary of Labor in the Trump administration, with us to share his experiences on political intervention in federal agencies. This is particularly timely with this recent release of the Durham report and significant whistleblower allegations that are floating out there. I will let Pat Pizzella, former Deputy Secretary of Labor and Pinehurst Village Councilman, introduce Mr. Scalia more formally in a moment. I had hoped to be able to introduce the new president of Sand Hills Community College, Dr. Alexander Sandy Stewart. You didn't sneak in, did you, Sandy? Well, if he does, I'll make sure we recognize him again. He's just been appointed. He's only the third president of this great community college. He's a Moore County native and has a strong background in agriculture. He previously served on the Board of Trustees here at Sand Hills. Effective July 1, he will be in the full-time business of growing successful students and citizens, so his ag background will work well. And he has a wonderful institution already in place to make that happen. All the best to him in his new role. Also with us, or on the list, and maybe not even here yet, is Stan and Jean Bradshaw, after whom this beautiful facility is named. If you dig a little deeper, you'll find their involvement is in much more on this campus and across the street at the O'Neill School. For instance, the newly opened nursing school facility, Founders Hall, has their handprints all over it. We need to thank Stan and Jean for all they are doing for our community. After Mr. Scalia's remarks and Q&A, there will be a reception in the lobby outside where you can interact with our speaker. I already heard a couple of good stories that I know you're going to look forward to hearing, Jean. One was about a case that was argued in front of your dad, so that's good. And thank you all again for supporting the James E. Holshouser Speaker Series. We will continue to honor North Carolina's 68th governor and his legacy of effective governance with informative speakers on the topics of the day. Just a reminder that our website is jhspeakerseries.com, where you can find recordings of past speakers, announcements on upcoming events, and where you can purchase tax-deductible tickets for those events. So stay tuned. Pat, if you can please introduce us to your former colleague at the Labor Department.
Thank you, Tom, for that introduction, and thank you to the James Holshouser Speaker Series for extending an invitation to former Secretary of Labor Eugene Scalia to address us at the Bradshaw Performing Arts Center's Owens Auditorium at Sandhills Community College. Gene Scalia's background is well known. Undergraduate at the University of Virginia, law school at the University of Chicago. He is one of 8 children of former Supreme Court Justice Anton Scalia, and he's a father of 7 children himself. I have introduced Gene many times in the past, but always when I served as his deputy secretary, and he was my boss. I had to be a lot more careful about what I said then, but not today. We have known one another for over 20 years. We started out as colleagues at the Department of Labor in 2001, very soon became allies involved in internal policy debates, emerged as friends, and were reunited at the Department of Labor in 2019. I want to share a couple of quick stories to put in perspective the type of leader Gene is. Early in the George W. Bush administration, as Assistant Secretary of Labor, I was facing the challenge of renegotiating the collective bargaining contract between the department and its employees. The previous administration had put in place some provisions that made it difficult to manage the department efficiently. The union kept filing unfair labor practice allegations, better known as ULPs, against the department while they refused to come to the bargaining table. So I instructed my staff to file a ULP against the union. My staff told me that had never been done before. I said, so what? The next thing I know, the staff lawyers from the solicitor's office came down the hall and advised me it was a waste of time and the department would lose. So I decided to appeal to my new colleague, the solicitor, Gene Scalia, and met with him where he summed up the situation well, as Gene would often do. He said, Pat, so you want me to overrule all my staff attorneys with the hopes of succeeding on a ULP where no other federal agency has succeeded before? I responded, yes. Gene thought for a minute, and he said, okay, I hope you're right. About a year later, we won our case before the Federal Labor Relations Authority, and 9 months after that, we had the contract we wanted. It was clear to me Gene Scalia was not reluctant to challenge the status quo, an important quality in navigating the federal bureaucracy and challenging the administrative state, as it has become known. During the ensuing 18 years, we remained friends, and then in July 2019, the President nominated Gene to be Secretary of Labor. I was Deputy Secretary and Acting Secretary at that time, and we coordinated on his nomination process. One day, the administrative officer of the department came to my office indicating that he had a call from nominee Scalia's office asking that the desk in the secretary's office be removed. So I was a little startled. I said, well, if that's what he wants, move it out there. And then I picked up the phone and I called Gene at his law firm. And I asked him, what was he planning to sit in when he gets into the secretary's office? He told me that when his father had passed away, Gene inherited the personal desk Justice Scalia had had at the Supreme Court. And Gene intended to bring it with him to the Department of Labor. I thought to myself, what a great thing that would be for all the visitors to the Secretary of Labor's office to see. And what a terrific sense of humor Gene possessed. I urge you to listen carefully to Gene's remarks this afternoon, because in many circles in Washington, D.C., when people speculate on an Attorney General and in a future administration, the name Gene Scalia is often mentioned. So it is now my pleasure to introduce one of America's premier labor and regulatory lawyers and the 28th Secretary of Labor of the United States, the Honorable Gene Scalia.
Thank you all. Pat, thanks for that Very generous introduction. Tom, thank you for the introduction, and thanks for inviting me to speak as part of the Holtzhauser lecture series. I'm thrilled to be in Pinehurst. This is my first visit. I've heard about it for many years from Pat and MJ, I've never regretted so much in my life as today that I don't golf. I don't, but I certainly understand why you all love this place, and am so happy to see my friend Pat and MJ in their habitat. As you heard, Pat's been a wonderful friend of mine for many years, and was actually one of the reasons that I became the Secretary of Labor. Pat encouraged me to put my name forward and to consider it at a time when I didn't think I was particularly interested. But I was, and was thrilled to have the job, and Pat was instrumental to virtually everything we did. I'll never, of course, forget the day I met with the President in the Oval Office to talk about the Labor Secretary job. We talked, he offered me the job, I accepted, and then he said, all right, I'm going to announce it. And I said, well, when? There's not been an FBI background check. I need to speak with people. I said, when? He said, now. I said, you know, how? He said, I'm going to tweet. And I said, well, you got to give me some time, man. He said, you have 2 hours. So, ran out, told my wife, my partners, my clients, but within an hour and a half, the news was out. But in any event, I met with the President, and he offered me the job. I accepted. I got up to leave, and he came up to me and he said, what do you think about the deputy that's over there right now as acting secretary? I said, he's terrific. I said, if that position were vacant, he'd be the person I would want in that job. He's fabulous. And the President said, I hear good things. You call him, you tell him that you're going to be the secretary and that you want to work with him. And that's what I did, and I was thrilled to do it. So, Pat, thank you. It's good to be here. So I'm going to be talking a lot tonight about the government, and it occurs to me I should make clear at the outset that when it comes to this country's founding in the Constitution, government was not the most important thing. Government was not the objective. As proud as we are of our Constitution, it was not the be-all, end-all. It was a means to an end. The objective was freedom. The objective was human flourishing. The framers were proud of the government they designed because they hoped it would provide space and freedom of movement for things that were more important than government, like faith or like free enterprise. I know that many of you spent your careers in business, or others spent your lives raising families. Thank you for what you've done for this country. As much as I value and honor government service, and I'll talk about that some today, I know that the Founding Fathers knew that the growth and success of this country would come principally from private citizens, individually and collectively, building and thriving in the conditions of liberty that were assured by the Constitution. That was the framework. Thomas Jefferson said, a wise and frugal government is one that leaves the people, quote, free to regulate their own pursuits of industry and improvement. He said, agriculture, manufactures, commerce, and navigation thrive most when left most to individual enterprise and freedom. One experience I had at the Labor Department that I'll never forget, it seems like a small thing, but it's always stuck with me. It was a 2-minute speech I gave. I'm probably the only person who remembers it, in part because I was one of 50 speakers, each of whom had 2 minutes. It was a meeting convened by the International Labor Organization. The ILO is part of the United Nations. It focuses on, as you would expect, workforce issues. And they called this meeting in May of 2020 to talk about how COVID was affecting workers and what our 50 or so nations were doing about it. As you know, this was a very, very challenging time. Just a couple months before, unemployment had been at a 50-year low. We'd been at 3.5% unemployment. The US economy had been creating jobs at an amazing, near record pace. And then within just 2 or 3 months, the bottom just totally fell out. We went from 3.5% to 14.7% unemployment just 2 months later. And that number was expected to rise. It was a really frightening time. So the ILO convened this meeting, and each labor minister spoke about the things that his or her country was doing to address COVID's impact on workers. We spoke in alphabetical order by country, so I was near the very, very end. And I listened to country after country. I can't tell you what they were all exactly saying, but basically it was the same thing. They were imposing requirements and spending money. Speaker after speaker after speaker was talking about programs their governments were putting in place, spending that they had authorized, and they were generally indicating that the workers' future depended on more government and on what the government did. Well, when I had started that call, I had planned to focus my remarks entirely on what we were doing in the government. But as I listened, I started totally rewriting my remarks. So yeah, I did talk about the CARES Act, which was a very consequential response to COVID in April 2020, and I think did some very good things. But I emphasized, as I spoke to them, that there was something more important to our recovery in the US, and that was going to be the strength and resilience of American businesses. And that's what my rewritten remarks reminded them. The single most important thing government can do for workers, I said, the single most important thing is create the conditions for a thriving business sector. It's private businesses that create most jobs, not the president or the labor secretary. It's private businesses that provide the pay raises, the promotions, and of course it's private businesses that are formed and financed and run and provide a livelihood for millions of individual American entrepreneurs. So absolutely the government has a role, an important role to play in supporting workers, but its first job is to, as I said at the time, assure free markets and free people and assure that it not interfere in the opportunities they provide. Well, that view of government and business and the impact on jobs and workers was central to the regulatory policies of the Trump administration. And Pat, I don't know if to avoid trouble I should call it the Trump-Pence administration, but that takes more words, so I'll call it the Trump administration. Those policies contributed to a period of spectacular opportunity for American workers. I want to reminisce about that for a moment because it holds a very important lesson that we have to carry forward as the debate continues about economic regulation and the role of government. In the summer of 2016, just a little bit before the 2016 elections, the Congressional Budget Office gave its estimates what was going to happen in the economy. It said that from the start of the next year, January 2017 to January 2020, it said the economy will create 1.9 million jobs. 1.9, that was the estimate. It said unemployment, it'll be at 5%. So what happened? Well, instead of 1.9 million jobs, the economy created nearly 7 million jobs in that period from 2017 to early 2020. Unemployment was not 5% at the start of 2020. As I said, it was 3.5%, which tied a 50-year low. Wages, meanwhile, grew at 3% or greater for more than a year and a half, and the last time there'd been wage growth like that was more than a decade earlier. So what changed? We had these projections in August 2016. We had this spectacular performance instead of those projections. Well, a lot of things affect economic conditions, obviously, but President Trump's tax cuts and deregulatory policies, I'm convinced, had a very important role in stoking the economy during that period. I also want to underscore who the main beneficiaries of that were. It was the Americans who historically have faced the greatest challenges in the workplace. For African Americans, Asian Americans, and Hispanic Americans, the unemployment rate and the poverty rate hit record lows in 2019. In that year, wage gains for those groups I just mentioned were greater than for non-Hispanic whites. And for adult women, unemployment hit a nearly 70-year low during that period. A lot of people like to talk about the so-called income inequality, the gap between rich and poor in this country. And a lot of those people who want to have that conversation would have you believe that the answer to that gap, the way to close the gap, is government, and government regulating business more to bring about more equality. But we had a chance to test that between two successive administrations. In the years 2010 to 2016, during the Obama administration, real net worth for US families in the lowest 20% of income earners actually dropped real net worth for the lowest income Americans. But for families in the top 10%, real net worth skyrocketed 24%. Put differently, income inequality got greater. Then, fast forward 2016, 2019, the opposite happened. For the top 10%, actually, there was a small drop in real net worth, whereas for the lowest income earning Americans, real net worth jumped 32%, a 32% increase during that period. So I believe that those 3 years, 2017 through 2019 until we hit the pandemic, tell us something critically important about policies that help workers. And it's an example not to be forgotten. If you set the conditions for booming business growth, many good things follow, and those include more jobs, higher wages, and more opportunity for people who historically have had less opportunity. Yes, those changes can be good for business owners too, but it can be greatly beneficial to individual American workers. And that view, that insight, was certainly one that we carried with us to the Department of Labor. I want to talk about a couple of things we did there. One was a rule we adopted about independent contractors. That's when a worker is an independent person in business for him or herself, rather than a company employee who's subject to the federal law regarding minimum wage and overtime, a law known as the Fair Labor Standards Act, or FLSA. The minimum wage and overtime protections of the FLSA, those are important. But also important is the ability of individual workers to go into business for themselves. When I was labor secretary, I often met with young people, and I'd say, hey, what do you want to do? What do you aspire to do when you grow up? And I was struck how often they would say, I want to start a business. I want to have my own business. It's what they wanted to do. Not once did somebody say to me, Mr. Secretary, I want to be an FLSA-covered employee. There's been an aggressive attack on independent contractors in recent years that's been led by labor unions and by some politicians, particularly in California. The independent contractor rule that we adopted, and Pat was actually a major proponent of it early on, was meant as a counterweight to that attack on independent contractors, and it was meant to provide clarity of when it was totally appropriate to work as an independent contractor. As with a lot of what we did during that time, the current administration is trying to repeal the rule and push the law back in the opposite direction. I'm hopeful that the approach that we took will ultimately prevail, if not within the Labor Department, then in the courts. Well, the opposition that we had to unnecessary regulations was also behind what was probably my most criticized decision as secretary. And, excuse me, that was the decision that we made not to have the Occupational Safety and Health Administration, also known as OSHA, the decision we made not to have OSHA issue a rule about COVID in the workplace. During the pandemic, labor unions, members of Congress, and some in the media tried to pressure us to issue a COVID rule. We were sued for not doing it. We won that. Instead of a rule, we issued guidance to industry and workers, both for general industry, general workplaces, but also specific sectors, retail, manufacturing. What's best, as we understand now, to guard against COVID in those workplaces? We did guidance because I knew from my time in the private sector that businesses like getting guidance from the government on its views, so long as that guidance is not actually a rule masquerading as guidance. Second, I thought that guidance during this time made sense because guidance is flexible. It can be changed, adapted relatively quickly. and call me crazy, but I wasn't 100% sure that the CDC knew all that there was to know about COVID. And I thought they might learn new things or they might even make mistakes. And if they changed their mind, I didn't want the prior view embedded in a regulation that would be very difficult to change. Part of the reason we wanted guidance, as I said, you can change it quickly. I also thought that making a rule would consume a lot of our time and energies. I thought it would be controversial. I thought it would consume employers' time. And I thought we would get bogged down in litigation. I thought that we would definitely end up in court. That was the approach we took. We never wavered. I believe we were right. But then, after I left office, I got this rare opportunity, and you all, every one of you, should get this opportunity at least once in life. And here's what it was. I had the opportunity to see somebody else face the same choice I did, make the opposite decision, and have it be a total spectacular failure. I didn't wish that on them, but it certainly was validating for me. For the first part of the Biden administration, despite all those attacks on us for not doing a COVID rule, they didn't do a COVID rule. But then, as you know, in the fall of 2021, the president, I believe, ordered OSHA to adopt a rule requiring companies to require workers to get vaccinated. And what happened? It took up a lot of time and energy at the Labor Department. It got the business community very, very wound up and confused, and it resulted in a lot of expenditure and anxiety on that part. And then, of course, it got enmeshed in litigation. The Labor Department was actually sued in every single court in the country that it could have been sued in over that rule. And as you know, it eventually went to the Supreme Court, and the rule was thrown out by a vote of 6-3. Interesting lesson. The result of that decision was that OSHA essentially ended up with less authority than it had had before it adopted the rule, because I believed when I was at the department, and I still believe, that OSHA has a very important role to play when it came to COVID in the workplace. But the Supreme Court actually kind of viewed it differently. They said that the Occupational Safety and Health Administration is about occupational hazards. And their view was that COVID's kind of an everywhere hazard. It's not really specific or unique to the workplace, or at least to most workplaces. And so by a vote of 6-3, the Supreme Court said, OSHA, COVID is largely not your responsibility, which certainly had not been the view during the Trump administration or during the Biden administration. So what happened? The government overreached, and it backfired. Over-assertion of agency authority resulted in less of it. That's an important lesson. I'll talk about it a little bit more tonight. I've been talking about deregulation, some efforts we made in that area. But I should be clear that from day one at the department, we also recognized our obligation, as the Constitution puts it, quote, to take care that the laws be faithfully executed. And that included the law governing workers' pensions, the law known as ERISA. We adopted a rule in this area, and I'm in a strange way proud to say, 3 months ago that rule resulted in the President Biden, exercising his veto for the first time. The rule was called Financial Factors in Selecting Plan Investments, which you would not think would get people wound up. But the rule had a simple message. Retirement plan fiduciaries, people who are trustees for retirement funds, have to manage pension assets with one goal, and that is maximizing investment returns for a secure retirement. There are trillions of dollars in private U.S. pension plans. That is not money that's there to be harnessed to pursue other goals, however worthy those other goals may be. To my knowledge, our rule was the first federal or state rule on what is sometimes called ESG investing. That's investing based on environmental issues or social issues, or to influence the governance, that's the G, to influence the governance of a company. When we adopted the rule, we were clear that there are times when environmental considerations are a very relevant factor in making an investment. You don't buy into a company with major Superfund liability without taking that into account, for example. My concern, though, was the growing interest some people have in using the resources and influence of the financial system to push policy goals, like addressing climate change. I didn't want private pension funds used that way. The way we put it was that ERISA plans further one incredibly important social policy, just one social policy, retirement security for American workers. That's one to be proud of and not to be compromised. Well, when the current administration came into office, it immediately put a hold on my rule, and last year it replaced it with a rule that's perceived as more favorable to ESG. In March of this year, the House and the Senate voted to repeal the Biden rule and to put my rule back in place. It's that bill which President Biden vetoed. So the Biden administration's rule is the law for now, but it is in court, and I don't think the administration has had the last word on this topic. This debate about ESG investing has just begun. We will see more debate and we will see more litigation. In fact, I filed a lawsuit of my own last month. My clients in this case, I'm back at my private law firm. My clients are New York City workers who participate in retirement plans offered by the city. We've sued those retirement plans for selling off all of their plan investments in oil and gas. This divestment from the energy sector was pushed very hard by the former mayor, de Blasio. Mayor de Blasio wasn't trying to do what was best for workers and retirees. He was grandstanding about climate change. I think he might have had a dream that if he did this, he would get all kinds of support for some higher office he thought he might get elected to someday. The city pension plan managers knew the mayor's proposal was problematic. They were wary initially, but eventually 3 of the 5 New York City pension funds climbed aboard. They sold off all the oil and gas investments, and they boasted about how they were using workers' retirement funds to supposedly stop climate change. But 2 of the 5 funds didn't do it. They blew the whistle. Appropriately, one of those funds was the police. The other was the firefighters. They refused to divest. The head of the police union, he said, quote, it's such a good statement. He said, quote, the money in the pension fund does not belong to us, nor to the mayor. It belongs to the active and retired police officers who have worked and sacrificed to earn their pensions. Our views on any social or political issue cannot enter into the equation. And the firefighters had what he said was, quote, we do not see our pension fund as an object to be used to make political statements. Our job is to provide for our retirees. And that, in a nutshell, is what the lawsuit that my clients have brought says, that the 3 other city pension plans put other interests ahead of the retirement security of city workers and retirees. What I've been describing, and it's using the financial system to push political causes, is an avowed goal of the current administration. They have signed international commitments to that effect. One example is an immensely controversial regulation being worked on now at the Securities and Exchange Commission, or SEC. As many of you know, the SEC is the agency that regulates public companies in order to protect shareholders. Among the things the SEC does, again, and a lot of you know this, is it requires companies to make certain disclosures so that shareholders can be alerted to potential risks in what they're buying. The SEC is now trying to use this shareholder disclosure system to force companies to publish reams of information about greenhouse gas emissions, among other environmental things. Not just those companies' own greenhouse gas emissions, but the emissions of those companies' suppliers, so-called upstream, and also downstream, the greenhouse gas emissions from the people that buy the product of the reporting company. Here's how costly this rule is. The SEC itself, when it proposed this rule last year, it said that these disclosures from this one rule, just about climate, are going to be 2.5 times more costly than all of the other disclosures we currently require companies to make on all other topics. One rule, 2.5 times more costly on this one topic than everything else the SEC is requiring disclosures on right now. And that estimate actually is a lowball, because when the SEC proposed this rule, companies came in and they said, no, actually, one or two companies said it's going to be hundreds of millions of dollars for our company to comply with this rule. And so you ask, wow, do shareholders need this information that badly to make good investments? Is climate information far and away more imperative for shareholders than all the other information that's currently being disclosed? Of course not. The SEC actually, to my knowledge, has not brought a single case against a company saying, oh, you didn't warn your shareholders about a big climate risk you had. This rule has nothing to do with protecting shareholders. What it's about, as I said, is using the financial system to force disclosures so that, to take an example, environmental organizations can attack companies that are large energy producers or consumers, and so that certain activist investors, like those New York pension funds, can attack companies for their environmental records. Well, this rule will be finished and published later this year. You will hear more about it. There will be, it sounds like, immediate litigation. And that litigation is going to be won in a series of showdowns between the overzealous regulators at some agencies right now on the one hand, and our federal courts on the other hand. And I want to talk about that showdown more in a minute or two. But first, I wanted to just mention a couple last things about my time at the Labor Department and address a couple questions that I get. One is, people often say to me, they say, you know, tell me about the deep state. That's the phrase they use. It's actually not one I use. They say, how hard was it to work with the career people in government? And I'm going to tell you something you might not actually expect to hear. You know, my answer to that is there were definitely challenges. There were certainly some people at the Labor Department who, at certain points in time, did not behave professionally, or who did not support the leadership whom it was their responsibility to follow. Managing in the government is very difficult, and the civil service rules are too constraining. But having said all of that, you get nowhere in the federal government declaring war on your own staff. It is not possible to run a federal cabinet department with just you and the handful of appointees the president is allowed to send over to help you. To run the federal government, you have to learn to work with the career civil service system. And you have to find and you have to work with the many talented, dedicated people who actually are there throughout the government. This is one of the reasons I was grateful to have Pat with me at the Labor Department. I don't know a better federal government manager than Pat, someone who understands how to manage personnel and budget in the government, which is part of the reason I told the president I want him there. Every day we did things to use the authorities that we had, knowing that civil service system, to enlist the support of the career staff and to move forward on the president's priorities. If we had tried to go it alone, much less sought to wage war on the staff we had, we would not have completed half of what we did in Washington. So people are right to be concerned about resistance within the government at times to what political leadership is trying to achieve, but they're sorely mistaken if they think the answer is to attack those folks once you're actually in the department and try to do the job by yourself. It's just not manageable, and I hope future administrations recognize it. So one other question I get sometimes about my time at the Labor Department is, what surprised you? What was surprising to you? What did you learn from being Labor Secretary? And I tell people the most surprising thing to me was how much I enjoyed giving out money. And I say this because as tax-paying Americans, this ought to really concern you, especially because I'm a limited government kind of guy. So let me explain. The lion's share of the Labor Department's budget is to make grants for worker training and the like. And everybody knows that a cardinal rule of government is that if you're giving out money, you show up and take credit for it. And so as we made grants, I would often go to small or mid-sized cities. To announce the grant, I would meet with the people receiving the grant who were, well-intentioned people working on valuable things. I would meet with local civic leaders who were supportive of that, business leaders, and also people in the government there. And the local media would also come because this was sometimes a few $1 million being given to a local cause. So there I was with well-meaning people trying to do valuable things. I was being treated really well. They were appreciative of that money. They were really grateful. They were nice to me. And also, they probably had an application to get more money the next year. So they were really nice to me. And then I would fly out of town and, I would know that on the evening news that night, there'd be a story about this really nice thing I'd done. And I came away from these trips with two thoughts. First, I thought, that felt so good. I want to just do it again and again and again. And second, I thought, this is really dangerous because this warm, tingly feeling I'm experiencing is felt by nearly every other cabinet member, senator, and congressman who's handing out money. That was something I learned that I had not appreciated until I was actually in that role, and it's one of the reasons our government is so large. I should make clear for the record, I never gave out a grant that I did not think was appropriate, as recommended by my staff. But still, what I experienced and felt is among the reasons our government's large. Excuse me. Well, I wanted to finish tonight by talking about another part of government, and that's the Supreme Court. The court has been in the news a lot lately, and it'll be in the news even more so next week when the justices finish their term. There might even be a case about North Carolina. There's a very important case about North Carolina, as I think you all know, having to do with the admissions program at the University of North Carolina. You should be proud of your Supreme Court. It is the most impressive, best functioning of the three branches of government right now. And it observes higher standards of ethics and integrity than any other branch of government. There have been a fair amount of press lately attacking the court in a variety of ways. In fact, there's a sort of pattern now where certain media launch a fusillade of attacks on the Supreme Court and then run a story saying, oh, it's terrible, public confidence in the Supreme Court is dropping. It's a pattern. It's a bit of a game. And there's been stories lately about trips taken by justices' friendships with business people and the like. But what I would say is this. People who care about the court don't worry for a moment that what the court did changed because my father went on a salmon fishing trip in Alaska in 2005, as was reported last week. People who care about the court don't think that a vote changed. They don't think that a single word in an opinion changed because my father took that trip or because other people took that trip. People who care about the court and who even worry about that institution, they worry about a leak of a Supreme Court decision months before it was issued. People who care about the court, who believe in the court and worry about the court, they worry about threats to the justices themselves. People who follow the court aren't worried that because a particular justice took a trip with somebody from a corporation, that how that justice voted ever was influenced in any way. We have members of Congress who are saying, let us, trust us to impose proper ethical practices on the Supreme Court, many of them being people whose livelihood is to vote in a way that is satisfying to people who will then give them money. I don't know that I would look to them to reform the institution of the Supreme Court. People who worry about the health of our Supreme Court worry about a virtual assassination attempt on a Supreme Court justice. They worry about somebody who's now the Senate Majority Leader, who stands on the steps of the Supreme Court and says that certain new justices will pay a price. They worry about that man saying that those justices, quote, won't know what hit them. If you're worried about the court, these actually are the things that you're worried about. There are probably not many of you who've had the opportunity to go to a Supreme Court argument, although I think I heard that maybe one of you had the pleasure or maybe the misfortune of arguing a case in front of my father, but if you ever get the chance to go to a Supreme Court argument, go. These are 9 hardworking, well-intentioned men and women trying to get the law right as they understand it. Read their opinions, same thing. They're not always right. I don't always agree, but they are 9 hardworking, well-intentioned men and women trying to get it right as they understand it. They are not perfect. But as an institution, the court is a lot closer to perfect than the president or Congress. If there's an institution in Washington that needs an overhaul, and believe me, there is, that is not the Supreme Court of the United States. So since there are a lot of, I think, misrepresentations about the court these days, I wanted to say a few words about what drives many of the justices of the Roberts Court. One is something called textualism. This is important to a number of the justices. This is the belief that a judge should base a decision on the text, the words of the law that he or she is applying. A judge doesn't base a decision on what he thinks or she thinks is the best policy, or even what he thinks or she thinks Congress meant to do. Textualism says you base it on what Congress wrote or what's written in the Constitution. Actually doing textualism isn't always easy because sometimes statutes are fairly complicated. But the concept of it is very simple. In fact, so simple that it might surprise some of you that that's not how it's always done. But it was not. For many years, if you pick up a Supreme Court decision from the 60s or 70s, you'll often see the court talking about some policy problem that was out there in society, about how Congress perceived that problem, about what Congress wanted to do to correct it. They'll quote what members of Congress said on the floor of the House or Senate. And you'll barely find where they refer to the words of the statute that applies to the case at hand, much less find where they interpret those words and explain what they mean and therefore the answer should be. All of that has changed. You might think that ignoring the words of a law that you're interpreting is sloppy, and it is, but it's worse than that. It empowers judges. A judge who makes a decision based on the words of the law is constrained by those words. A judge, though, who thinks that his job is to decide the best policy outcome is a judge who has a lot more room to roam. A second key consideration for a majority of the court today is what's called originalism, and this relates to the Constitution. It says that the words of the Constitution should be interpreted according to the meaning they had when that constitutional provision was adopted. Originalism says it's not a court's job to update the Constitution or to adapt its meaning to changing times. It's not the court's job to bend the Constitution's meaning so that, in the view of 5 justices at least, that meaning is now more in line with the values that we hold today, as if 9 lawyers from Harvard would know. They're not all from Harvard. Some went to Yale. The Constitution definitely can be updated. We have an amendment process to do that. It's not a judge's job. Originalism was what you saw with the Dobbs abortion decision last year. The media portrayed that decision as 5 justices who were determined to turn the clock back or to outlaw abortion. But a year later, we know, of course, that's not what the court did. It gave the issue to America's elected representatives. The justices in the majority there said that the laws about abortion are a subject for our democracy. The Constitution, they said, doesn't hold the answer one way or the other. The view that the Constitution did speak to the subject of abortion only started getting voiced fairly recently in our history. And it never, ever, as you all know, fully gained acceptance. It was intensely controversial from the day it was announced until the day it was overruled in Dobbs. And the justices in the majority there explained that's part of the reason they did overrule it. Does this so-called original meaning approach to the Constitution mean that new practices or technologies that we have out there today are outside the Constitution and somehow can't be addressed by the Constitution? Of course not, although that is another myth that you'll hear. The Fourth Amendment is a good example. It protects us from government invasions of our home, into our papers, and from unreasonable searches and seizures. And those principles speak directly to new technologies that threaten those constitutional liberties. Justices who believe in original meaning and using that method have recognized the Constitution's applications to new technologies in numerous cases. The difference, though, is between protecting original rights from new intrusions and, on the other hand, creating entirely new rights that the framers did not recognize in the Constitution itself. Well, the third key issue in the mind of many of the justices today, and the last that I'll mention, is the separation of powers and what that means for the administrative state. I see this as the most interesting area of law before the court right now. It's interesting in part because of President Biden's very aggressive regulatory agenda. I already mentioned the SEC's controversial climate rule. The Federal Trade Commission has proposed a rule that would outlaw non-compete agreements in employment almost entirely in all 50 states. This rule is absolutely, totally unsustainable. I had a piece about it in the Wall Street Journal. It will never become law. It'll be struck down immediately, but nonetheless, they're trying to do it. I mentioned OSHA's vaccine rule. I mentioned the current Labor Department rulemaking seeking to reverse my rule on independent contractors and to adopt a narrow and, I think, unprecedented approach to who's an independent contractor. It's been said that President Biden aspires to govern in the progressive manner of President Franklin Roosevelt. But the huge difference is that Franklin Roosevelt had large legislative majorities. And so President Biden instead is trying to deliver Rooseveltian results through federal regulatory agencies. And unfortunately for him, his timing could not be worse. His rules are coming before courts and before a Supreme Court that is highly suspicious when regulatory agencies take on responsibilities that belong to Congress or that belong to the courts. The Chief Justice, Justice Thomas, and Justice Alito have long had a strong interest in these issues. And President Trump's three appointees have made a huge difference in this area. If you go through them one by one, every justice appointed by President Trump is more interested than the judge he or she replaced in identifying and enforcing limits on the administrative state. So Justice Barrett is more interested than Justice Ginsburg was in identifying and imposing limits on the administrative state. Justice Kavanaugh, more interested in that than Justice Kennedy, and even Justice Gorsuch, more interested in identifying and imposing those limits in at least some respects than Justice Scalia was. What you're going to see in the next couple of years is a clash between the Biden administration's view of the administrative state and the courts. And in fact, you're already seeing that. The administration has been overreaching, and the courts have been striking things down. Again, the OSHA vaccine case was an example of that. We saw it in a very consequential decision last term invalidating the EPA's Clean Power Plan. And we saw it in a decision that some of you may remember from 2 summers ago, where the Supreme Court rejected the CDC's so-called eviction moratorium. This was the time where the president said, well, you know, we're going to give it another try. My lawyers tell me that it may not be legal, but at least we'll be able to have it in place for a little while before the courts strike it down. And, well, he was right, at least in his predictions, if not in his approach toward governing. We'll see that same clash potentially in the case that's currently before the court involving the administration's forgiveness of hundreds of billions of dollars of student loans. That same clash between the administration's view of a very powerful, expansive administrative state and the skepticism that the courts have about those kinds of exertions of authority, their belief in a more traditional separation of powers. And we may also see this clash next term when the court considers whether to overrule the so-called Chevron doctrine, which, as many of you know, involves times when the courts will give deference. They'll adopt the interpretations of the law that are put forward by agencies. For those concerned about overreach by aggressive federal regulators, these are fascinating times and they are promising times. And as this clash occurs, I want you to remember, too, that it does not result from political views that the justices hold, their policy preferences. It results from this judicial method, which I've talked about. They're interested in originalism, in the separation of powers, and how they believe that the framers would have understood the operation of the administrative state. I wanted to finish tonight with just a few words about my father's friendship with Justice Ginsburg, which is something else that I get asked about frequently. Many people, they're interested, and they say to me, so amazing that they were such good friends, Justice Ginsburg and Justice Scalia, even though they were so different. And I have two responses to that. I say, first of all, they weren't really all that different in a lot of ways. They actually had a lot in common. They worked at the same place. They had the same job. The last job they had was the same, too. They were, in the D.C. circuit together. They're both New Yorkers. They're about the same age. They loved music. They had a lot in common. But the other thing I say second and more important, my father and Justice Ginsburg did have differences on important issues. But they weren't friends despite those differences. They were friends in part because of those differences. They exchanged ideas from different perspectives. They valued that. They wanted that. It made them more knowledgeable. It refined and sharpened their ideas. It may have changed their minds sometime, probably not all that often on some of the biggest issues that came before them. But it frequently helped them express their ideas better and more precisely and with more understanding. That exchange of ideas between them just made them better at their jobs, and guess what? We, in our democracy, we benefited from that. I hope that people who admire my father or who admire Justice Ginsburg won't just look at that friendship as some kind of weird curiosity. Hey, look at those people there. I hope they'll look to it as an example of how they can live their own lives. These were two strong-willed people with diametrically opposed ideas on some huge issues. As colleagues, they clashed, but they talked, they remained friends, and we all benefited from that. That's a lesson for us and for this democracy that we all love. Well, thank you very much for having me speak to you tonight, and I think I was told I will take some questions. And something else important I learned as labor secretary was that you can take a question, you just don't have to answer it. So I'll exercise that prerogative if I want.
Thank you. Thank you so much for your remarks. I really appreciate them. I would like to just talk about two things. First of all, the Keep 9 amendment to the Constitution. I understand that very recently Al Sharpton and Jesse Jackson have been talking about pushing to pack the courts.
I'm sorry, pushing to do what?
Pack the Supreme Court. And so there is a Keep 9 amendment out there working its way. I just wanted your comment, but I do want to talk about regulations because that's...
Give me your other question too, I'll take them both.
Okay. On July the 5th, which is coming up really soon, folks, the EPA, Environmental Protection Agency, has a regulation proposed to limit the amount of gas emissions, carbon emissions from gasoline-powered engines. This will affect passenger vehicles, light trucks, and SUVs. And I understand, so I'm urging people to comment on that, because as a citizen, that is your right, and we have to exercise those rights. But I've also heard that the Biden administration is trying to limit our ability to comment on a lot of regulations. By the way, I am a nerd, and what I do is try to educate people about the Federal Register. So,
that's pretty nerdy.
It is very nerdy, but I am concerned because if the Biden administration can limit us from commenting, that is taking away one of our basic rights. So thank you very much.
With respect to
my question also, I just want to piggyback on
if it's all related, sure.
yeah, it's 100% related. Could you break it down for the layman on what has to happen in order for court packing to occur? Meaning the justices going to 11 to 13 to 15, and how soon, if that happens, will it be 31? You know, and so what are the impediments, or what has to happen?
I mentioned Franklin Roosevelt. One of the most controversial and least effective things that Franklin Roosevelt did was attempt to pack the court. I think he wanted to increase the number of justices, I think, to 15, because he'd become very frustrated that the court was striking down some of his New Deal initiatives. That plan failed. It was considered to reflect very poorly on him. It was viewed as abusive of the court, although his supporters would say, but the court began to suddenly like his legislation and struck down less. And there has been talk since the start of the Biden administration about increasing the size of the Supreme Court so the president can immediately put a number of justices in the court who he expects will be more favorable to his initiatives. The president, to my assessment, has recognized the problems with that, even if he doesn't want to publicly admit them. One of the very first thing that he did in that area was to create a commission to study the problem, which those of us who've been in government understand is usually a way to put something on ice for a long period of time. The idea will continue to get attention. It's one of the reasons that control of the Senate is extraordinarily important. If indeed you had 51 senators agree to eliminate the filibuster, then increasing the size of the court is something they could attempt to do, although they're not going to get it through the House of Representatives right now, are they? That will be an ongoing battle, and the mechanism for doing it would be relatively straightforward. It would just be enact legislation to increase the size of the court. But the Supreme Court has not always had 9 justices. It's been smaller than that in the past. It's by statute that it's 9, and that statute can be changed. The other question was about the EPA rule. Shame on me for not mentioning these EPA rules. Thank you for doing so. It's 2 separate rules, one regarding so-called light and medium-duty vehicles, the other regarding heavy-duty vehicles. And it's an attempt by the EPA to force electronic vehicles on the economy. The requirement under each rule is that a very large percentage of a car manufacturer's fleet, I think one of the target years is 2032, not that far away, a huge percentage has to be EVs. It's a major restructuring of the auto industry to force the internal combustion engine off the market. It's going to generate an enormous amount of public comment and litigation. To me, it's another instance of an agency that was established for one purpose, trying to do something very different. I do not think the EPA was established to determine whether or not we would even have gas-powered cars anymore, but that's what they're trying to determine. I have not heard that the administration is trying to prevent people from comment. There have been a number of times that agencies have only allowed a relatively brief period of time to comment, maybe 30 days. People complain about that. They want more time. Sometimes they get extensions. But I'm not aware that actually getting your comments in has somehow been obstructed by the government. And if it were, it would be an added reason for some of these rules to be thrown out, because allowing the public to comment in a rule, allowing the public to give input is actually an important part of the democratic process when you have such a large and powerful administrative state. Question here.
A question about the leak of the draft Supreme Court decision on Dobbs, the abortion decision, whether you think we'll ever learn how that happened. It's
guesswork. Maybe someday the person who did it will claim credit, although that person has by now committed a federal crime, because I believe that everybody who would have been in a position to leak it was asked by a federal agent whether or not they did. And lying to a federal agent is a crime. So I don't know whether or not the person who did it will admit it. I don't know whether more evidence will come forward. Sometimes reporters reveal their sources. That's really rare. But that leak was extraordinarily disturbing to the court. I tell people sometimes that you still can't see draft opinions that my father wrote. A draft opinion that my father wrote in 1987. It's not publicly available. His papers are at Harvard Law School. Our agreement at Harvard Law School is that none of my father's court papers, none of the memos, the drafts, can be seen by the public until a year after all the justices who served with him that term have passed away. Justice O'Connor is still alive. So my father's court papers aren't even available. And this wasn't something that I made up or Harvard made up. I spoke to the justices and to their staff, and this was the kind of approach that I sensed they wanted. And it's what I think my father would have wanted. It's in that context you consider an active opinion got leaked. It was extraordinarily troubling to them. And as I said, that is a threat to the institution, not a salmon fishing trip in Alaska. Yes.
First of all, thank you again for coming down here, sir. We really appreciate it. My name is McLean Conlon. I'm a rising high school junior here in Moore County, and I hope to go into appellate law, so I found your talk fascinating. I was hoping to just ask a quick question about the issue of standing. It's an issue the court's been very interested in this term. For example, a few weeks ago, the court held that non-Indian parents did not have standing to challenge the Indian Welfare Act. Just yesterday, the court held that Texas and Louisiana didn't have standing to challenge the Biden administration's border policies. And I'd like to hear your thoughts on that, because here you have two very important constitutional principles: the right to challenge government overreach in a federal court, and also at the other time, these standing rules restrain the power of federal courts. So I would like to hear your thoughts on that. Do you think the court got it right in the case yesterday? Some very vigorous disagreement between Kavanaugh and Alito. I just want to hear your thoughts on that, sir. Thank you.
Very, very, very good question. You're obviously a thoughtful young man. I hope he doesn't watch this. I'm sure he won't. My son, who's a high school junior, he's not asking me this question. I'm very proud of him. But he doesn't ask me these things. Standing is the idea that you have to have your own personalized concrete injury in order to bring a lawsuit. And you have to be able to sort of benefit personally from a ruling in your favor if you win. And a number of the justices regard standing as a really critical adjunct to the idea of separation of powers, because the Supreme Court cannot issue what we call advisory opinions. It decides cases between real people. We can't have people who have a grievance with Congress going to the court and asking what's essentially an abstract question and getting the court to invalidate what Congress did. That's one of the roles that's played by standing. I believe my father wrote an article about standing as an element of the separation of powers. And it was that concept that we can't have courts issuing advisory opinions, stepping into legal debates when it's not an actual case involving real people who will be affected by the outcome. These particular decisions, you're ahead of me, pal. I mean, one of them came down yesterday, so no, I haven't read that. I was coming here. And the other, my firm actually handled. One of my partners argued the case involving the Indian Child Welfare Act, and we were disappointed with that outcome. But I don't feel I'm in a position to critique the court's assessment. But thank you.
Thank you, sir.
I very much enjoyed your speech today, or your talk, and I suspect everyone here was grateful that you came. And you've talked primarily about a topic that I'd call overreach. But there is a topic that the government pursues these days, which is called underreach, and that involves the border. And I was wondering if you had thoughts about that.
I don't know that I have much to say about the problems at the border beyond what is widely said by people concerned about the administration's current border policies. I will say that we are a nation of immigrants. My grandfather came here. I had lunch with a colleague yesterday whose husband was born in Hungary. His parents are still there. He eventually came here. His parents just barely survived the Soviet domination of Hungary. Our nation benefits by having him here to explain to his son, who, by the way, is a law student, the difference between this system and other systems and the greatness of the freedoms we have here. I mean, we're a nation of immigrants. We benefit from immigrants, and I'll never back away from that. But we also have rules. So we are also a nation that believes in the rule of law, and you got to be able to control your border. I do believe if you can't control your border, you ultimately are at peril of losing your national identity. I just have to say, I've been reading too much Roman history lately. And about 200 years of it involves people pouring into the Roman Empire from across the Rhine, across the Danube, and eventually Rome itself losing, to some extent, losing because it lost its identity. I'm not comparing what's going on at our border with that, but borders matter. You see it throughout history, and we have to take ours more seriously. Yes.
Yes, thank you, Mr. Secretary. I'm curious, for all the different Republican candidates, I'm interested to see what they're going to do to reform federal government. I spent another career in state government in a state other than North Carolina, so I have a huge suspicion of government when they say we're here to help. Vivek Ramaswamy says if the president has 8-year term limit, that so should the bureaucracy and the bureaucrats as well. And I'm just curious of what you would think of that.
I don't have a view about that particular proposal. As I said, there are many really talented, good, well-intended, and effective people in government, and I think it's important to acknowledge that, and I think it's important when you come into an agency to acknowledge that and find those people and work with them. But as I also said, it is very hard to manage effectively in the government. And anybody who's run a business understands how critical it can be to just be able to hire the right people and also to let people go when they're not doing a good job. And of course, we understand that just the fact that you could let somebody go, lo and behold, it sometimes incentivizes really good performance. And the original idea of the civil service system was to avoid a spoils system where somebody got elected, fired everybody, put in a bunch of unqualified cronies. We don't want that. But we've certainly lurched very far in the other direction, which has made it too difficult to manage well. In the employment in this country generally, we believe in at-will employment. And we've adhered to at-will employment in part because people who manage companies believe that that's what enables them to run that company most effectively. And I'm not advocating at-will employment in the federal government, but our government would definitely be better. It could be smaller, more efficient, more responsive if people who manage in government were freed up to do it more effectively. And by the way, that's not just the view of people who hold political appointed positions in government. I think there are many senior government managers who themselves are there throughout their careers who wish they had a better ability to effectively manage the people that report to them. Yes?
Your father was known for his dissenting opinions, much like Oliver Wendell Holmes, Jr. What do you think was his most far-reaching and significant dissenting opinion and majority opinion?
My father's most consequential dissenting opinion, that's a pretty easy one to answer. That was his dissent in a case known as Morrison v. Olson, which had to do with the constitutionality of the so-called independent counsel statute. This was the statute that authorized, on a referral, I think from the Attorney General, the federal courts to appoint somebody to investigate federal officials. And so the most famous independent counsel is probably Lawrence Walsh, who was appointed to investigate Ronald Reagan in connection with Iran-Contra. Ken Starr, who was appointed to investigate the so-called Whitewater Clinton issues, was also an independent counsel and maybe even better known. My father in Morrison v. Olson was the sole dissent, saying that that provision was unconstitutional, saying that the president is given the responsibility, and the president alone, to take care that the laws be faithfully executed, and that you can't have a go-behind where somebody else suddenly is given in charge of law enforcement instead. A lot of the debate about separation of powers and about problems in the administrative state has to do with the president's ability to supervise the federal government and all of it. And the independent counsel statute was an example of that. My father was a sole dissent. It was a wonderfully written, very compelling opinion. And it is now an opinion that I think is largely viewed as correct. When that statute expired, it wasn't renewed. And I think it was acknowledged that my father had been right. He's lone dissent. He was right. And of course, part of what happened is Republicans hated the statute because people used to go after Reagan. And then Democrats hated because it was used to go after Clinton. And some of my Democratic friends came up to me during the Clinton investigations when Ken Starr was the independent counsel, and they said, you know, Gene, your father, I don't like what he writes, but his Morrison v. Olson dissent, my Democratic friends would say, that was brilliant. That was so good. And I would tell him, I'd say, you know what? The funny thing is my dad, he realizes now he was wrong. He takes it all back. He didn't. He never took it back. He's very proud of it, but I enjoyed saying that. My father's probably single best-known majority opinion is in the Heller case, which recognized that the Second Amendment right to own and bear arms was a right held individually, that it was not simply one that in a sense belonged to the states and had to do with militia, but no, that individual people have their own right, which they can enforce against government intrusion. But his contributions go way beyond that. I talked about textualism, how important that is to the court now. I talked about originalism. My father was the foremost proponent on the court of textualism and one of the 2 or 3 foremost proponents of originalism. He really did change how the court and courts approach the law, and that was done through many opinions over time. Thank you all very much.